I see you, Mr. Solomon. I don't see Mr. Banks yet. There we go, Mr. Banks. Very good. Mr. Solomon, you may proceed.
Thank you, Your Honor. May it please the court. My name is Sandy Solomon, and I represent Pharmacy Value Management Solutions, to whom we refer as PVMS. This is actually a very interesting case because PVMS is the operating subsidiary of a publicly traded company, and Judge Stevens, in the Katzman case, was very sensitive to that issue. In fact, he was so sensitive and so cautious that instead of appointing a receiver, which is essentially the guts of the June 4th, 2018 order found at the record at 837, is really a step down from a receivership, but all of the provisions associated with the receivership are contained in that order. And the order specifically identifies PVMS, and it says that PVMS and its subsidiaries are prohibited from dissipating any of their assets outside of the ordinary course of business without the approval of the special master or an order of the Judge Stevens court, at the time the Complex Business Litigation Division. That was a relevant issue during all of the negotiations. In fact, the very first email that's sent by Mr. Banks to PVMS counsel, Mr. Koss, on January 18, 2019, acknowledges that fact. It says, in negotiations, your side, meaning PVMS, kept including approval of the settlement by a special master. So I put that in the attached, which is when they say the agreement was codified, and the agreement, the terms of the agreement were set forth in a written document that then later was circulated for signature. And as a result of that particular provision is found in paragraph 2G in virtually every draft. There was one that went back that didn't include it, but it was included there. And in fact, in that unfortunate email from Mr. Koss that they rely upon, the February 14, 2019, which is Joint Exhibit 21, that chain of emails specifically includes an email that says that we must have pre-approval. We forwarded the settlement agreement to the receiver or to the special master for review. It's necessary for him to review this as we were required in the other court proceeding. So when they say there was no response and no objection to this, that's hardly the case, because they themselves acknowledged that this provision was a key component of any settlement, even if we ignore the writing or the signature requirement for the moment. And it's very important, I think, that something that you look at the global nature of this settlement agreement. What they tried to do by their own email exchanges, all in evidence, is to insulate themselves against an avoidance claim in a bankruptcy that might subsequently be filed. So what they were doing was essentially, in this settlement agreement, attempting to usurp the powers of the receiver or the trustee in bankruptcy, and by including paragraph 2F, that they were going to have a perfected security interest on all receivables, all assets, all computers, all office furniture, et cetera, et cetera. And in the event that they file, that PVMS does file for bankruptcy, they want to jump the pack to have their antecedent debt treated as though it is a properly secured obligation. That's something that clearly needs the special master's approval if that's going to be read in tandem with what they knew from the absolute genesis of this relationship. Because if we go back to the date that they're talking about, as Mr. Burris's testimony says, well, we had an agreement, and the judge's order, which adopts Mr. Banks's argument, was effective January 18, 2019, when they just sent the draft. And the reason that they say that that's effective was because it was pure poppycock that they had to have it appointed, approved by the receiver or the special master. and before it became effective. And that's merely an expression of their own confusion and failure to do the investigation of what that meant, because they knew all along, and in the documents, in the emails, that this was a condition precedent to any approval of any lump sum payment, any settlement of any lawsuit, any dismissal of any counterclaim. And my job, I suppose, in part today, is to tell you why you should bother sending it back, because we do admit that there was some money that was owed. The money that we paid was what was owed for the CPAP equipment. The dispute in the underlying case that hadn't had a chance to germinate was whether or not the supplies associated with the operation of the CPAP machines should be charged to PVMS when those sales took place without the involvement of PVMS. So there was a substantial dispute, and nothing in this case did they give up, did Rotech give up, because this settlement agreement that they're talking about does not trigger any remedies or relief whatsoever for PVMS unless and until the entire amount is paid. There's no release. All of the triggers in all of the provisions, I don't have to go through all of the things for you, but you can take a look at the most relevant provisions, which is in paragraphs 3A and 3B, which specifically say that Rotech's release becomes effective only upon the settlement sum being paid in full, but PVMS's release is effective upon execution of the agreement, which was never executed. So now let me turn.
Mr. Solomon, let me ask you a question on this. The written agreement was never fully executed.
Correct.
Yet there was compliance with the essential terms of the agreement as far as the payment amounts and the due dates and so forth. And the trial court conducted an evidentiary hearing. And as a result of the evidentiary hearing, the court basically concluded there was the meeting of the minds for purposes of a settlement agreement on all material terms. I'm not 100% certain, but could the court have been concluding that at some point in time, the necessity of the written agreement was gone because the parties reached a settlement and there was payment in accordance with what the testimony apparently was at the hearing in terms of how this was settled?
You are dead on point. That's exactly the problem with this. They sued to enforce this specific written settlement agreement, and the court's order enforces this written agreement with all of its defects, all of its flaws, all of its security agreements, all of its other things, which never could have happened. I also take issue, by the way, with the fact that the payments were made in accordance with that. What they did was they discussed making payments for those aspects of the claim that were really undisputed. Isn't that what we want people to do so that they can wipe away those differences? And they made those payments up to the point that they felt that that satisfied their obligations for the CPAP equipment, not for the supplies or any other disputed charges that were associated with it. And the point that you raise really goes to the third point in my brief, which is this is really not handled the right way. We have to have pleadings that talk about what the terms of that oral agreement or unconsummated, unsigned agreement have to be so we can respond to that. Because what happened, if this had been a de novo case—
Your client did not back away from the statement that he wrote, which is, I agree for all practical purposes, the partial payment constitutes the completion of the contract by part performance.
Well, there's two questions that I'll address in there. One is with respect to the unfortunate statement made by Mr. Koss.
Unfortunate or not, it is your client's statement, and that came out at the evidentiary hearing, right?
Sure, but that's his opinion, and that still never stopped the fact that they were trying to enforce the written agreement. My argument is that even if that were true, that engenders a requirement that they specify the specific terms of the agreement that they're seeking to enforce. And that would be done by a supplemental pleading, because under a supplemental pleading, if it were a de novo case, if it were at the outset, they'd have to, they would be subject to a motion to dismiss if they didn't articulate in the pleading what the terms of the agreement were that they were seeking to enforce. I don't think it was all of the material terms either. You say that we complied with the material terms, that we did make payments of things that were undisputed. The rest of the agreement and the circumstances under which it was presented were disputed. There is no dispute that there is some money owed, and that that has to be fleshed out. Essentially, we're giving them the benefit, and the trial judge the benefit, of having pled waiver, for example, and unspecified terms without having to plead that case. That's exactly the issue of what has happened since, to suggest that their claim is related to the claim that was originally asserted under an entirely different agreement, pursuant to which they were an assignee or a subcontractor, is pure sophistry, because the settlement of that has to do with the special master, when the payments were going to be made, and the distinction between the equipment and the supplies, which is the only real issue as to whether or not when they're going to litigate. But the amount that is owed was in dispute, and they gave no consideration for reliance upon either this partial payment, which this opinion was months afterward, after the payments were made and months before they signed it. They went back and decided that they had to have a signed agreement. And even though Mr. Burris kind of, in his testimony on pages 42 and 43, he says, well, we didn't know anything about these conditions preceding. There was nothing in the agreement. When it was pointed out to him, he says, oh yeah, but that was merely a red herring. We didn't know anything about it. That's
Mr. Solomon, on the issue of the special master, was there, what evidence was there, if any, at the hearing as to the delay with the special master's response?
Oh, I don't think there was any evidence. I agree that it would have been nice to have learned what that was. I wasn't the trial lawyer.
But there wasn't any evidence that your client was somehow delaying that aspect of it?
No, ma'am, no complaint whatsoever associated with that approval. And in fact, the joint exhibit 21 that has the unfortunate cost email and the email from Mr. Height that says, hey, I still need pre-approval. I submitted it. I think they'll approve it, but that's all it is. He's thinking that that's the case. So I don't know whether Judge Silverman's question superseded the issue of this enforcement of this actual written agreement or not, but all they do to seek it to enforce that issue is to say that they were never told it was not enforceable, that they were never told that it was a problem, that they never received a written complaint. They never were told that the special master had rejected it. That doesn't constitute an agreement. To the contrary, the evidence was it was never signed. They were never told that it was approved. They were never told that it was accepted. They were never told that it was good in any way, but they were told that the document required that prior approval. So what they're saying is that they want to be able to enforce this by claiming that the partial payment, regardless of what Mr. Koss said, let's just take it, the fact is, regardless of who said it or when he said it, the partial payment waived all objections to the otherwise unsigned and unapproved settlement agreement. How could that possibly be when you've got a 5-page or 6-page settlement agreement that has everything but the kitchen sink in it and is completely one-sided? So you can't really blame them for wanting to make sure that they get an opportunity to address it after they complete the analysis with the special master. And I go back to this issue. We wouldn't have this confusion of what was to be enforced on what terms if 1.190 had been satisfied. That's the whole purpose behind it. We didn't get a chance to complain that there was insufficient allegations in the complaint where, as a matter of course, a trial judge is going to dismiss a complaint that is based on an oral agreement without specific terms. And I dispute or I don't know, that's not the right word. I disagree with Judge Morris when you say that all material terms had been complied with. They didn't make the payments on that schedule. The payment schedule that we complied with was not the same schedule. It was the original schedule that in our brief we identify as the original offer we made to them that they soundly rejected. And we made the payments according to that schedule, not according to the schedule that they gave us in the January 18, 2019 draft at the end of the day. I think I'm pretty close to my end. I don't.
Let me ask you, you didn't ask about rebuttal time, and you are right at the 5-minute mark.
That's what I was pretty much keeping track. I'd like to reserve the rest of my argument.
Very good. Thank you, Mr. Sullivan. Mr. Banks.
Thank you, Your Honor. May it please the court. My name is Brandon Banks, and I represent the appellee Rotech Healthcare Incorporated in this matter. As far as the factual and procedural background of the case, I'd like to rely upon my brief in order to save time for argument on some of the legal issues and some of the factual issues that Mr. Solomon brought forward. And one of those things that I would like to bring up right out of the gate involve, he talks about that, well, we made some partial payments, or PVMS made some partial payments in order to satisfy what we felt, what PVMS believed was due to be paid to Rotech. That's a nice after the fact spin, but there's no evidence from the evidentiary hearing on that point. Everything revolves around the testimony and the documents. And there was conflicting testimony that was presented at the evidentiary hearing. The trial judge considered everything that was presented by the parties. And Mr. Solomon, he says, well, rule 1.190 wasn't complied with. So we didn't have an adequate opportunity to be able to respond to the arguments that Rotech made. Well, to quote Mr. Solomon on that, poppycock. There was more than, well, first of all, rule 0.190 of the Florida Rules of Civil Procedure. The rule does not require that enforcement of a settlement agreement have to be brought via a cause of action in the complaint.
So just to be clear, because I was waiting for this, with regard to the pleading requirements, your position is this was a motion to enforce a settlement agreement, not a complaint. So it wasn't necessary for you to set up a formal affirmative defense of waiver.
That's correct.
Okay.
That's correct, Your Honor. I mean, and all the same process that would have been provided was provided through the motion to enforce the judgment. There was adequate notice of Rotech's arguments of enforcement of the settlement agreement, just like a pleading. There was an adequate opportunity for PVMS to raise defenses against the requested enforcement, just like pleading would provide. An evidentiary hearing was supplied to present all evidence that both sides had to defend either for or against enforcement of the settlement agreement. PVMS had an opportunity to cross-examine Rotech's witnesses. And PVMS had an adequate time to prepare a defense to the hearing and file a written brief in opposition to it. It took over a year between the filing of the motion to enforce a settlement agreement before the evidentiary hearing could finally be had. PVMS had a year. They knew exact arguments.
So under PVMS's theory of how this should have been pled, they should have had the opportunity, and presumably did, to submit a written opposition, and then you would have been required to reply in avoidance with a waiver argument. Am I right?
Can you rephrase? I'm sorry.
You're addressing his argument that the waiver theory was not adequately pled by your client within the meaning of the rules of civil procedure, right?
Waiver, I mean, a waiver.
He's saying that you didn't adequately plead waiver in moving to enforce the settlement agreement. That's what we're dealing with, right?
I would argue, Your Honor, that, we did.
I'm not disagreeing with you. I'm just trying to smoke out in sort of succinct linear terms how that could even have happened.
Okay. Oh, I see. So in the normal course, it would be, a complaint followed by an answer and affirmative defenses, followed by a reply in which I would allege an avoidance of the affirmative defenses. I would submit that's not necessary. I mean, everything was completely covered in the motion to enforce a settlement agreement. And again, PVMS had an entire year, a year, to put something together in response to all the arguments that they knew we were going to make. And it's not like all of a sudden, and Mr. Solomon keeps referencing draft settlement agreement, draft. There was a draft settlement agreement that went back and forth. And there's email correspondence that's in the joint exhibits that were introduced at the evidentiary hearing. Those
Which seem
culminated
to confirm that the terms generally of the settlement agreement were consistent with what the parties agreed to, right?
Yes, Your Honor. Either email negotiations back and forth and that were reduced to writing. And at the culmination of it, the January 18th email, I did attach a copy of what was the final version of the written settlement agreement that embodied the parties' negotiations. And what happened after that, it lays out a schedule of payments to make, and it has 6 payments. And the 6 payments were made, albeit not timely. They were in default on a number of those payments. And what my client did was serve them with a default notice pursuant to the settlement agreement. And
then they cured, right?
Yes, Your Honor. The first 6 were cured. The 7th one, which was a balloon payment, was not. And it was cured. When they were cured, there was nothing from either Mr. Koss, who was their litigation counsel, or Mr. Mark Height, who was the president of the company, saying, wait a minute, what are you talking about? It's a default provision. You notice we haven't defaulted. We don't have an agreement. Nothing, not a single word of that. And that fanciful argument wasn't created until the 7th payment, which was the balloon payment, was due.
Well, Mr. Banks, I mean,
They didn't make the balloon
fanciful, whatever you want to call it. Your client and you knew at the beginning of the settlement agreement that they had required the special master. I mean, we can't look over that at all. There is some importance to that, and we don't have it in this case. So what is your response to getting around the special master, other than that this is a red herring, if I don't find it to be a red herring?
Well, Your Honor, first of all, there was no evidence presented at the hearing that the special master provision was
the settlement agreement offered into evidence?
Yes, Your Honor.
Okay. Well, then there was.
There was no, okay.
Was the email from January 18th? The email from January 18th was offered,
Yes,
right? Okay.
Yes,
So we have two pieces of evidence.
Okay. I see the distinction you're making. Okay. What I'm trying to say is that there was no explanation provided by PVMS as to that aspect of it in the manner in which Mr. Solomon is trying to argue. But at the end of the day, even if
let me ask it this way: was there any evidence that the special master signed off on the agreement?
Directly, no, but implicitly, yes.
Oh, okay. Well, then you need to explain the implicitly how, if a contract requires that a special master sign off, where implicitly and how are we to rely on that?
Well, okay, Your Honor, as the trial court correctly found in the judgment, and Mr. Solomon referenced Joint Exhibit 21, which is part of the record. Joint Exhibit 21, there is a statement from Mr. Mark Height that was forwarded by Mr. Koss. Mr. Height's the president of PVMS at the time. And he said that he sent everything over to the special master, and he's expecting to hear back within about a week or so. Thereafter, PVMS continued to perform under the settlement agreement, promising to sign it.
Okay, but how does that implicitly, other than saying, hey, we in good faith are trying to make sure that this goes through, that we've sent the information that we need to get approval, and we're waiting to hear back. And one, they certainly can't bind the special master, and I don't think you're saying that, but I don't see how that satisfies the condition.
Well, there was no evidence presented otherwise, Your Honor. There's absolutely no evidence presented by PVMS at the hearing that a special master disapproved of it. For all we know, that PVMS dragged its feet, and Mr. Height in his email could have been lying. We don't know, but what we do know is he said
There's
that
not evidence of that either. But there's not evidence of that either.
There's not
Okay.
evidence of that either.
Okay.
That's
So you're
supposition just as much as Mr. Solomon.
okay. So basically, what you're saying is because there's no evidence that it was approved or no evidence that it wasn't approved, therefore, the court was correct in enforcing it, and we should affirm.
Not exactly. I mean, it wasn't in a vacuum. PVMS.
Wait, I have a question for you. On this issue, you file your motion to enforce the settlement agreement. You set up your bona fides that you say are the reasons why the trial court should enforce it. Was it your burden to prove that that condition had been met, or was it PVMS's burden to establish the lack of approval as a defense?
I would say it would be PVMS's, as a defense, which
To enforce them.
yes, yes, Your Honor.
And then to follow that, your position is there was no evidence that there was no approval.
That's correct, Your Honor.
Either way, and therefore
Either
they
way.
didn't carry their burden.
Yes, Your Honor. And, moreover, that they testified, or the email talks about expecting to hear back from the special master within a week or so, expected to be approved, and thereafter continue to perform, continue to make payments, respond to notices of
Almost
default,
in
with repeated
estoppel.
promises to sign. So, yes, Your Honor. So if the special master was as big of a deal, as they claimed, or that approval hadn't been received, then we certainly would have heard of that. Special master didn't approve. Their conduct
Mr. Banks, let me ask you a
indicates
question.
that there was approval, or there was.
Mr. Banks, I'm going to ask you a question that I think, at least for me, is a significant part of this. Did the trial court determine that the written settlement agreement was to be enforced, or did the court determine that by the parties' conduct, the essential terms of the settlement were agreed upon, and either the signature and special master approval were conditions that had been waived, or were they not necessary because the parties had agreed by conduct on the settlement agreement? And I'm not sure the court specifically addresses that, so help me figure that one out.
My understanding of what the court or the trial court determined, Your Honor, was that that the parties' conduct indicated that the essential terms of the settlement agreement were adhered to, and that the special master provision was not a condition precedent. But even if it was a condition precedent, that the conduct of the parties, very similar to the Foster case that's been briefed, in our response brief, that there was evidence to demonstrate that the condition had been met because PVMS's conduct after submitting it to the special master indicated as such. And there was absolutely no other evidence at the hearing to the contrary, other than PVMS's conduct after having submitted to the special master. That conduct indicates that approval had been received, just like in the Foster versus Housing Authority case that's cited in the briefs. Same kind of concept. You had parties in that case that wanted that intended a written agreement, or that their settlement agreement to be reduced to writing and to be signed. You had conduct of the parties, including one like PVMS, refusing. Well, in the other case, it was even ratcheted up a notch because they refused to sign it. PVMS kept promising to do so, but in any event, in the Foster case, after refusing to sign the settlement agreement, they then engage in one final piece of negotiation to settle on a monetary amount of an item that was concluded in the contract. And that was verbally agreed to, but nothing again was ever signed. So the conduct that occurred after the document being reduced to writing was sufficient evidence to uphold the jury verdict to find that a settlement agreement in that case existed. And there, without evidence that it was approved by the Housing Authority, because the conduct of the parties indicated that the Housing Authority had approved. So our case is very much like Foster in that regard. But at the end of the day, there is no evidence that it was rejected by the special master. And all the evidence points to the conduct of PVMS having gotten that special master approval, because they would not have done the conduct that they did if they hadn't gotten it. Because if they hadn't gotten it, we certainly would have heard.
It seems to me that if you are trying to enforce the written agreement as a written agreement, it requires a signature and approval of the special master. But there is an alternative that seems to be what the trial court focused on, is the essential terms of an agreement had been reached and there had been performance up to a point. So
Yes, sir.
again, I'll go back to what I said earlier. Is the court determining that there was waiver of signature and waiver of the special master? Or is the court saying that, look, that document just tells us what the basic terms were. You've abided by those terms. There's an email that says, essentially, we've got an agreement. And so whether it's the written agreement or an agreement by conduct, it sounds like you can't tell us what the court focused on.
I based on the language of the trial court's judgment, Your Honor, I can't.
I mean, she doesn't make a finding of waiver, and she doesn't make a finding that these are not conditions precedent. She makes a finding that the parties have reached an agreement, and I'm going to enforce the agreement that they reached. And here is evidence of what that agreement was.
That's correct.
All right.
If there are no further questions, I'd like to rely upon our response brief.
Thank you very much. Mr. Solomon,
Thank you.
you obviously have heard these last few questions. So what's your interpretation of what the trial court did?
I'm all over it. The trial judge approved the settlement agreement as written and submitted, and Mr. Banks's draft is what the judge adopted. And you can tell in the adjudicatory provisions on page 7, not only does she say in accordance with the settlement agreement that these amounts are going to be paid without adjudicating, as you say, the waiver, but also awards attorney's fees under the agreement. So the agreement must have been what was validated, because that couldn't happen otherwise. And there's the rest of it is the rest of the order can only be interpreted as a whole, as validating this particular written agreement, and that just was not the case. And that's a defense that we could have just put up.
Let me ask one more question on that, because the trial court, I think, arguably concluded that your client's conduct essentially ratified and adopted the agreement. And by going forward with its conduct, it was no longer requiring as a condition a signed agreement signed by both parties or approval by the master. If we conclude that the transcript of the hearing contains evidence that supports that kind of conclusion, how do we reverse it?
First of all, you have to reverse those portions of this that are based upon the settlement agreement, such as the attorney's fees. Secondly, there isn't any valid basis upon which to ignore the agreement between the parties regarding the condition precedent and the absence of that. The condition precedent has not been, could not have been satisfied. And to address Judge LeBrit's question, which I obviously understand where she's coming from, that Mr. Banks's answer I disagree with. When I plead a breach of contract claim, one of my elements of that cause of action is that all conditions precedent have been satisfied. That's the plaintiff's burden to come forward. And if they're relying upon their motion as sufficing for a pleading, that's not true either, because they never raised the condition precedent as I read it. And I've just gone over it quickly while we're here just to make sure. And I could be mistaken, but I don't think so. There was no reference in the motion to enforce that they were overcoming or satisfying this condition precedent. And that overrode every other issue, Judge Morris, Judge Silverman, because that issue ultimately was driving the train, because you have balloon payments, payments for antecedent debt, security interests that are being sought, delays of enforcement, Those are issues and schedules that have to be approved pursuant to the plan that was put up in neon lights from day one. It was originally, it was made an issue in December of 2018 in the evidence, and then reiterated when the settlement agreement. So as far as the agreement to the material terms, the only thing it reflected an agreement on were the payments that were made. Those were the terms with which we agreed. That's what we were validating. There's no indication, Judge Silberman, to address your point head on. There's just no indication that anything beyond the payment schedule that was satisfied was agreed upon. How could it be interpreted as anything other than that? And certainly,
it's interesting. Your client's position at the hearing was that it rejected the settlement agreement in its entirety. Did it ever communicate that rejection?
I only know what's in the evidence, and I don't believe that was specifically approved, but it was always held up because there was this special master requirement. The evidence is replete with references to that, and they just chose to ignore it because they never had come in contact with that kind of a remedy that we know is.
He says on page 117 of the transcript, and preceding that, he talks about the negotiations and the discussions and why he made payments. And then he says, when did you see, he was asked, when did you see the agreement? And then he's asked on line 18, did you approve or reject the settlement agreement? And he answered, it was rejected. But as I went through the record, I didn't see anything conveying any rejection of the agreement until after this all came to a head when the balloon payment was not made. Am I missing something?
No, I think I think you're reading it that he said, I rejected it. I didn't send it back. That was my rejection. It's a little bit like Brooks kind of a thing, you know, where we have you send out 100 resumes, you get 11 no's and 89 no responses. It's like you got a rejection, right, for the 89 no responses.
Let me just let you know, we're at the end of the time. So unless one of the other judges has a question, I'll give you 15 seconds to conclude.
The condition precedent was not satisfied. It was their burden to bring that issue to the head or to show that it was satisfied. I can't see that the burden ever devolved upon us, and the circumstances of 1.190 would have satisfied it. Thank you.
Very good. Thank you both very much.
Thank you, Your Honor.
Don't forget to press your exit button on your computer. The next case is the state of Alberico versus Baca and Palm Gardens, etc.